Welcome to this week's episode of On Record PR. If you're a regular listener, welcome back. If you're joining us for the first time, I'm Gina Rubel. Today, we're diving into the Supreme Court decision in Ames versus Ohio Department of Youth Services and what this means for all employers, including many of our listeners that are law firms. And with us today is Eric Meyer, a founding partner of Pierson Ferdinand and the brains behind the Employer Handbook. Welcome, Eric.
Thanks for having me, Gina. The brains behind the Employer Handbook. First time I've ever heard that one. I don't even think my dad would say that. Let's just give me publisher.
Okay, I'll give you publisher. I've been reading that a long time.
Thank you.
It's been one of the things, and it's one of the reasons you've become a known name in this space. And I think it's really important because this case that came out for us yesterday, for our listeners a few days ago or a few weeks ago, depending on when you listen. But the Supreme Court delivered a unanimous decision on June 5th in Ames versus the Ohio Department of Youth. And this is really a timely conversation. Could you tell our listeners the basic facts and issues in Ames?
Sure. It's not all that complicated. So in Ames, first, the court unanimously struck down a rule that imposed, I should say, an extra legal burden on a so-called majority group plaintiff under Title VII. What does that mean?
Right.
Majority group. In this case, we're talking about a heterosexual woman, Marlene Ames. So that would be the majority group, and someone who is different sexual orientation, would be not the majority group. Really stereotypically think white male versus that would be the majority of the majority. But in this particular case, we're talking about a heterosexual woman who works for the Ohio Department of Youth Services in various roles. And in 2019, she's passed over for promotion and later demoted each time she claims in favor of gay colleagues. So she files a lawsuit against the agency under Title VII, which is the federal civil rights law that governs discrimination based on sex and now sexual orientation, gender identity. And she loses at the lower court. She claims she's denied a promotion and demoted because she is not gay, because of her heterosexuality. Is that a word? Because she's straight. Okay. And the lower court applied this rule that says in cases like these, where you're in the majority group, you have to demonstrate that the employer, the defendant, is the unusual type of company that tends to discriminate against people in the majority. And the Sixth Circuit Court of Appeals affirmed this because that was the test in the Sixth Circuit. And they essentially said that Ames couldn't get to trial because she couldn't prove that her employer was in that rare group that tends to discriminate against majority group employees.
And for those listeners who didn't go to law school, I think the common vernacular for these types of cases are reverse discrimination. And that's what we're seeing in the headlines of your mass media and things like that.
That gets it above the fold, right? In quotes, right. Reverse discrimination. Yeah. Lawyers
we don't
now
use that in the courtroom, but but that's what we're seeing in the headlines. So I want to make sure that people understand what we're talking about. So what was the original purpose of Title VII?
The original purpose of Title VII of the Civil Rights Act of 1964. So the original purpose was to protect marginalized groups, specifically based on race. That was the genesis of Title VII. And then if you're a history law, employment law wonk like me, you know that gender was put in as a poison pill to try to undermine and stop the passage of Title VII, but it backfired, so to speak, and gender became a protected class under Title VII. So at its origin, it was race and gender, and then it was color, religion, national origin,
LGBTQIA plus, or and as I know, many of my friends like to say, the queer community. So what happened yesterday? What did the Supreme Court rule, and what was their reasoning?
So the court ruled that Title VII protects individuals, not groups. Courts can't make plaintiffs prove more than they were discriminated against based on their identity. Okay. And the burden at the first step of a discrimination case isn't really supposed to be that hard. So I'll try not to nerd this up too much. But basically, when you have one of these cases where someone claims I was demoted because of my sexual orientation, or I didn't receive a promotion, right? They have to show what's called a prima facie case at the outset. Just kind of like the makings of a discrimination claim. We'll call it that.
And so
And
I remember that being when I used to practice law, that's like the face of the case, the key issues you have to be able to prove, right?
Yeah, like in this particular case, Ms. Ames would say, I am heterosexual. I applied for this job. I didn't get it. And someone outside of my sexual orientation did get it, right? That is a prima facie case here. Then the burden shifts to the employer to show that there was a legitimate business reason for why Ms. Ames didn't get the promotion or was demoted. It's a very low bar too. Okay. And then the third step of this test, it's called the McDonnell-Douglas test, is the burden of persuasion and proof shifts, the ultimate burdens shift to the plaintiff to show that, well, the so-called legitimate business reason espoused by the employer is a pretext for discrimination. You can show that through inconsistencies, incoherencies, contradictions. So think about maybe two documents contradict each other, or two people at deposition contradict each other from the employer side. These are the types of disputed material facts that get you past what we call summary judgment to trial.
Okay. So the court rules that in this case, that Title VII protects individuals, not groups. And then the burden is lowered or raised?
Well, it's in terms of having to prove your case at the end of the day, you still have to show you were discriminated against, right? Whether you're in the so-called majority group or you are someone who is, that's why Title VII was created in the first place. Whoever you are, if you claim discrimination, you got to prove it. You got to prove it. But what you don't have to show, if you're in a majority group, is that your employer is the unusual type of employer that tends to discriminate against people in the majority. So in that regard, it effectively lowered the bar.
Got you. So we're going to take a quick break for a message from our sponsor. And listeners, when we come back, we're going to talk about why this matters to employers.
This episode is brought to you by Furia Rubel Communications, a public relations and marketing agency serving law firms and businesses worldwide. With an expert team positioned throughout the U.S. and supported by an international faculty, Furia Rubel enhances our clients' brands through integrated communications by providing expert guidance in crisis management and high-profile litigation, protecting brand and reputation, and supporting internal marketing teams. To learn more, visit furiarubel.com.
Well, welcome back. Hi, Eric. We had
Gina.
That nice little message. And so we're talking about Ames. We're talking about Title VII. What is the message for all employers, including law firms? What do they need to understand as a result of this case? What has changed?
Not much. Bias is bias. The legal standard doesn't change based on who you are. What could change going forward is this McDonnell-Douglas test we just talked about. So Justice Thomas, joined by Justice Gorsuch, may use the case to criticize the whole McDonnell-Douglas framework. Justice Thomas called it a judge-made construct that doesn't appear anywhere in the statute, and he's right, and suggested it might be time to toss it all together. So I would anticipate for you law wonks out there that at some point in the next term, they might take on a case where they get to decide whether the McDonnell-Douglas test is the proper test, or consistent with Rule 56 of the Federal Rules of Civil Procedure, all you have to show are material facts that are in dispute that summary judgment shouldn't be granted.
It's really interesting. So I want to talk a little bit about procedure here. So really what the court, from what I understand from our pre-recording, is that the court is basically saying, not that they're saying we see discrimination in this case or we don't see discrimination. They're just saying that the lower court needs to hear the case
They're
from the
saying,
perspective of, do they have a prima facie case? Am I getting that right? Because I haven't practiced in a long time, as you know.
since the lower court applied the wrong standard,
Okay.
the lower court will need to reassess the summary judgment motions on the proper standard. So it is possible that under the proper standard, Ms. Ames hasn't produced or hasn't shown disputed material facts, which would get her to trial. It is also altogether possible that she could, and then it would be up to a jury to decide whether she was discriminated against. But that's her ultimate burden.
So essentially, this is just giving her another day in court. It's saying
this is giving her a lifeline. Yes.
Okay. So I think that helps for people. And especially I have a lot of friends and colleagues in marginalized groups, and a lot of the headlines can be pretty confusing. So this is just saying she's going to have another bite at the apple because they applied the wrong standard. So, but that doesn't mean that there is discrimination. That just means she's going to get the opportunity to start over again.
Marlene Ames hasn't won anything yet.
Gotcha. So why is this case important to employers, including law firms, which is the majority of our audience? And how does it affect the legal industry's challenges regarding diversity, equity, and inclusion? Because we're in a new world in 2025. There's been a huge sea change.
Yeah, it's keeping me busy. It's going to put my kids through college. This isn't just a tweak to courtroom rules. It's a reminder that you need to apply your internal policies. How you apply them matters. You need to apply them consistently, right? When you're investigating complaints, for example, or responding to allegations or making employment decisions, the same rules apply regardless of who brings the concern. This case came before the Supreme Court while the Trump administration has been targeting diversity, equity, and inclusion programs and practices throughout the federal government, in law firms, and in large companies. You asked about DEI. I'm going to pivot just slightly. You might remember the Students for Fair Admissions case. It involved Harvard University, in which the Supreme Court ruled that Harvard's admissions process, which considers race as a factor, violated what we call the Equal Protection Clause of the 14th Amendment. Okay, this ruling effectively ended what we called affirmative action in college admissions, meaning universities can no longer use race as a factor in their admissions decisions. All right, hard stop right there. DEI is different. It's not affirmative action. It's not inherently unlawful. Okay, DEI programs aim to promote workplace diversity and inclusion. These are good things. However, there's another Supreme Court decision worth considering here, and it's called Muldrow versus City of St. Louis. And it's a recent decision, and the court unanimously held that an employee need only show some harm when claiming discrimination. It doesn't have to be significant or material. It effectively lowered the bar for someone who is bringing a discrimination claim in order to get to trial and potentially to verdict. So if you are faced with an adverse employment action, it makes it easier to bring those discrimination claims.
Okay.
In light of the Muldrow and Ames decisions, certain DEI efforts could potentially lead to claims, not actual disparate treatment, but claims of discrimination, disparate treatment, if they result in any disadvantage to employees based on protected characteristics. So, for example, think about a DEI program that includes race-restricted access to mentoring or training programs. That's exclusionary. Or if promotions are influenced by demographic targets, employees who are excluded or adversely affected might claim discrimination under Title VII. And I'm saying this stereotypically and anecdotally. More likely than not, those would be employees, individuals who are in the majority.
Okay.
Right? The so-called majority.
So
Go ahead.
Well, because of all that, though, what should employers be doing, including law firms, to comply with Title VII and with Muldrew and all of these decisions that are affecting the way we hire, the way we recruit, the way we promote our diversity and inclusion programs, or many of which are becoming culture and inclusion now. What do we tell the employers?
How much time do we have? I'm kidding. We'll keep it to like, we'll keep it to 6
hire
bullets.
me. No.
Right.
Not me.
We'll keep
I
it
don't
to
do
6
employment law.
bullets. What should employers be doing? Employ non-biased hiring practices based on merit. Presumably, employers have been doing this all along. Continue to do it. Make decisions based on merit. Review internal complaint procedures to make sure that they're treating people equally. Use consistent documentation in how concerns are addressed. Reinforce that your policies protect all employees. That can be in the handbook, training, Gold Star if you're doing both. Follow the same procedures for every complaint. I mean, every complaint's going to be a little bit different, but the procedure should generally be the same. So you avoid the optics, the impression that you're treating people unfairly or disadvantaging people in how you investigate complaints. And then avoid assumptions based on an employee's demographics. So we're talking consistency, fairness, documentation. They remain your best tools for minimizing legal risk.
So in so doing that, what are some ways to anonymize the information? So for example, you get a resume, somebody's got to get the resume. How do you anonymize it so people are just looking at the resume on the merits? What shouldn't people be looking at?
Well, the name could give away male, female, or someone could read a name and say, well, this is a name that's stereotypically associated with this religion or this race, right? Or, if I see Gertrude applying for a job, I'm thinking this is an older person. Okay. I don't know many, none of my kids are hanging out with Gertrude. So removing some of those personal identifiers as much as you can, and then just focusing on the skill set and the experience that is baked into the resume.
And I think that's a really important takeaway, because there's so much inherent implicit bias in the way we think. And you just, when you mention the name Gertrude, I'm thinking, okay, that's somebody's grandmother from Texas, like great grandmother. And so you build these pictures in your head that create implicit bias. So by removing those things and focusing on this person can do this skill, this person can complete these tasks well, this person can help you, with your KPIs, all of those things, I think is a really important tip. And hopefully everyone listening is moving in that direction.
I think they've been doing that for, since the beginning of, I don't say since the beginning of time, but in the modern era, I mean, that's the way people should be running their business.
That's the way they should be. I'm going to beg to differ with, I don't think they all do. I think there's that's why you're in business. or the plaintiff side are in business, and then you're doing the defending. But I don't know that everyone does. And I think it's really important, because that's one of the challenges with some of the DE&I programs we're seeing in the legal community over the years. I'm not going to name any of them. I don't want to get into that. But what I want to say is it really is based on merit, focusing on merit. I, for one, as a woman lawyer, have been very happy to see a lot of these DE&I programs over the years in the legal industry. I often say that my dad went to law school. He graduated from Temple in 1971, I believe. He had 2 women and 2 people of color in his class, in his law class. So back then, there were very few people to get the jobs. And, if you ever listen to Ruth Bader Ginsburg's, how she was told she was taking up a man's spot in the law school classroom. So we go back to some of these things, and I hope there's a sea change now in our industry in particular, that is merit-based, that is focused, that does allow room for everyone of all backgrounds so that we can have diverse and inclusive teams.
I agree with you, Gina. And I think specific to law firms, I work at a distributed law firm. We have a DE&I group. We just had our meeting the other day on Teams. But I think of law firms generally, and I'm saying this anecdotally again. I imagine that some may be concerned about having affinity groups, right? If we have a women in the law group or LGBT attorney group, right? Is that going to expose us? Well, if you make it exclusionary, it will. But let's take the LGBT example. Now, I don't know this for sure, but I would imagine that people who are in the LGBT community, who are members of that group, would welcome allies, people who are heterosexual, to attend these meetings, right? That makes it a stronger group, right?
It's interesting. You know,
inclusivity.
I've heard arguments on both sides, and I'll just say this. Last week's podcast that we did with Elizabeth Ogilvie and Sarah Larson was about employee resource groups, ERGs. And I have always thought they should be inclusive because I've always wanted to learn from the people who have felt marginalized and learn how to get better at who I am and to show up as a better leader and all of those things. However, in an organization that I'm a member of some years ago, I wanted to participate in the LGBTQIA SIG so I can learn from people, and I wasn't allowed because they wanted a place where they felt safe. And I respect that. However, I do think there is an opportunity, and we need to make these, or the people should be able to listen, participate, learn, support. And I do hear that a lot are the employee resource groups are becoming more issues based, like caregiver groups. And like when I had young kids, I was a caregiver, and now I'm in my young middle age, I like to say, where I have an aging mother-in-law, people that we care for. So having other people who have gone through that, things like that. But then there's also that whole idea of if you're going to invest, you have to invest equally.
Well, and let's bring it full circle, right? These are the types of cases that we could see in the wake of Ames. Someone who says, I was excluded from this ERG group, and because I was excluded, I wasn't exposed, or I didn't have access to the same mentoring opportunities. And because I don't have access to the same mentoring opportunities, my opportunities for advancement in the organization are hamstrung. Okay? That's Muldrow, right? It doesn't have to be a significant harm. It just has to be some harm to terms and conditions of employment.
I really appreciate you taking that full circle, because it reminds our listeners, those who are in the HR departments or doing recruiting or making the decisions, where the bar is now and what we might be seeing in the future. But I think we've come to our time. So I want to thank you for joining us today. Last minute, right? I called you this morning, said, can you jump on our podcast? So I'm really honored that you can be here. I'm very disappointed that you didn't wear your Eagles shirt. Just to let you know.
I was on a client call just before this.
I know, but I'm a diehard.
Yeah.
So, but I want to say to our listeners, if you found today's episode helpful, please subscribe and share it with a colleague, and consider leaving a review on iTunes. Please continue to share your feedback and ideas with us at podcast@onrecordpr.com. And we'll see everyone next week. Thank you.
Go Birds.
Go Birds.
On Record PR is produced by Jennifer Simpson-Carr and Matt Henderson, with support from the team at Pierson Rubel Communications. This episode is edited by Isabel Horan and Christian Yamula. Visit www.onrecordpr.com for resources and more information.